To give equal importance to the opinions and insights of our country's youth and research scholars, we invited their presentation to represent their thoughts in the form of research papers. We have received numerous research papers from different parts of the country that have touched different dimensions of RTE Act. I must say that all the papers were very illuminating and creative. Among these participants, we were compelled to select 10 research papers which were more explanatory and innovative to be presented during this conference. Now, without any further delay, let's start with the paper presentations. Each presenter has 5 minutes to present their paper. I would like to invite Mr. Shrirang Ashtaputre and Ms. Sanjana Kulkarni from ILS Law College. Their topic for the paper is Mandatory Online Education as a Violation of Right to Education of Children in India.
I hope I'm audible and visible.
Yes.
Yes.
Yes, perfect. With the permission of the panelists and the organizers, we would like to begin.
Yes.
Yes. Okay. Good afternoon, respected dignitaries and my respected co-presenters. I, Shrirang Ashtaputre, along with my co-author Sanjana Kulkarni, both final year law students of ILS Law College, Pune, are truly honored to have secured a chance to present our insights and views penned down in the form of a short research article titled Mandatory Online Education as a Violation of Right to Education of Children in India. Due to the paucity of time, I request the panelists to allow me to present the paper all by myself. Thank you. I'm assuming that I'll present the entire paper by myself because we just have 5 minutes. So distributing would be a little difficult if that is okay.
Yes, sure.
Okay, thank you. So through the medium of this paper, we have provided an exegesis for the readers of the recent judgments of the High Courts of India with regards to online education undertaken by private institutions and their attempt of securing the payment of fees even for miscellaneous facilities under the guise of such a scheme. As of today, the government of India is obliged to assure free and compulsory education for children between the age of 6 to 14 years, thereby enabling them to stand on their feet and make a living for themselves. It is a common knowledge that education is the basis for earning bread and sustaining in this cruel and capitalistic and rather information age. However, the socialistic principles by which the Indian state is expected to abide by has permitted to enforce the aforesaid mandate even against private educational institutions to a certain extent. We all are aware about the obligation of schools to accommodate children of poorer strata in an attempt to eradicate the rising economical division in the society and enabling equal opportunity of better learning for all. This is suggestive of willingness of the legislature to incorporate the Western principles of horizontal interpretation of fundamental rights, that is, to make private citizens responsible for the rights of other individuals of the state. Interestingly, even the judicial establishments of India have assessed the said aspect of law and on a few instances applied the same for assuring maximum protection to people. To put it simply, a private institution could be amenable to the writ jurisdiction when, in public interest, it becomes necessary for casting positive obligations upon it and for protecting and promoting the interests of citizens at large. That is to say, both the public and private educational institutions could be deemed responsible for protecting the rights of education of the citizens therein. Now, the fact that the consumer forums have also acknowledged that disputes pertaining to educational institutes may fall within their ambit on a few instances, of course, and that the schools are obliged to protect, it appears that even private education institutions could be held that even they could be held liable for protecting the right. Therefore, by allowing schools to undertake online classes and even collecting full fees, the authors opine that the schools, especially the private unaided ones, have violated the rights of children to education, besides failing to secure their privacy and compromising on their right to health. Every establishment failed to realize that not every person has reasonable access to internet facility in India, although it is a fundamental right. And even if one did, not everyone has money to constantly pay for the data and recharge, especially due to the lockdown, which has halted the income of the members of the poorer strata. Now, without any further ado, I would just like to present the judgments of the high courts, which have been instrumental, the courts which have been instrumental, in actually protecting the rights of citizens against the private unaided ones. I'm not going to go into the depths of the judgment just to which has been dealt in the paper. Rather, I'm just going to list the judgments, list what exactly was held by these courts. So, It was, as I said, it was the high courts which came to the rescue of the parents and the children in matters of online education. For instance, the Delhi High Court was right in directing both the public and private educational institutions for proffering their students with technological equipment necessary for online attending online classes. The High Court of Uttaranchal directed the private educational institutions to secure payment from students who had no access to online materials. The Himachal Pradesh High Court struck down the notification which made the payment of tuition fees to private schools optional, where the High Court of Kolkata directed such institutions to allow students who had failed to make the payment of fees to attend online classes till 15th August 2020 and initially and now extending it to 8th of December 2020. Even recently, as of 13th October, Calcutta High Court has come up with a judgment wherein it has directed private education institutions to try not to, to reduce the fees by 20%. So then we also have the Madras High Court, which has managed to balance the rights of the schools and the teachers with that of the students by permitting the collection of 40% of fees in advance and demanding the payment of remnant by September 2020, and warned institutions of charges with contempt if the order was ignored. This is really important and we should note this. Finally, even the Rajasthan High Court allowed institutes of similar nature to collect 70% of the tuition fees in installments. Now, by stating all this, we are trying to say that okay, high courts, at least some high courts, there were actually 12 to 13 high courts which dwelt upon this issue, and the aforesaid 6 high courts have really come in favor of students and their parents whose
Yeah.
livelihood is already at stake.
So Shrirang,
So
I would request you to conclude, please, because we are
yeah,
running out of
so
time.
yes, I totally understand. So in our paper, we have also come up with suggestions, and if I could get just 1 minute, I would summarize very quickly. So what to do if such a situation is to happen again? So that is also what the authors have covered, and I'll just take 1 minute to cover it. Firstly, providing education can wait till until the threat of the lives of the citizens is negligible. We need to understand that livelihood of parents is at stake, and then they are already threatened that okay, if I don't provide education to my children, then I am also liable for no, I'm breaching my duty, I'm legally liable, and so they are already under a threat. So they have to first make sure that their financial stability is clear. So for that, I believe that providing education could have waited to a certain extent, which wasn't covered, considering our financial situation of the country. Then online learning, if at all undertaken, should be made optional and must restrict itself to innovative yet crucial subjects such as logical reasoning and Vedic maths, nuances of emergency responses, knowing your rights of duties as a citizen of India, and teaching a foreign or an Indian language as the case may be. Even in the case of tuition fees, where students are not able to pay the complete fee, they should accept payment in installments. The teaching and non-teaching staff must prepare themselves for a reduced income. This is really crucial. The amendment to the Right to Education Act 2019 is imperative to the extent of allowing school to secure lesser fees in times of such crisis. Interest-free loans for students between the age group of 6 to 14 years for the purpose of paying fees to institutions. Similar privilege to the persons engaged in teaching the said age group for coping up with the financial losses. And finally, issuance of notification by state governments for pertaining the school for preventing the schools from hiking their fees during the pandemic and collecting only the tuition fees, and the courts to respect these guidelines in general interest of the society. So all we are trying to say is the truest meaning of education, that includes both sports, personal learning, and other curriculum learning, should be incorporated and presented to the students in a manner which is not. Thank you.